So, Peter, what are you
Lori.
making today?
So today in honor of my friend Pierre Poireau, who is one of the world's oldest Michelin 3-star cooks, he's going to be 90 next year, we're making escalope de saumon à l'oseille, which is a dish that got him and his brother Jean, who's now passed away unfortunately, their third Michelin star in Rouen in 1968. And it's a classic. It's just a beautiful, beautiful dish that takes salmon and pairs it with a very, I was going to say light, but after you saw the creme fraiche I put in here, you might disagree, but a lightly flavored salmon-based sorrel sauce finished with shallots, white wine, and vermouth.
It smells incredible.
So what's going on?
So the first thing I thought we might discuss is about common law versus marital situations, and who would be sort of entitled to what in a common law situation if separation occurred.
All right. So the first issue between common law and married, obviously, is the very obvious, which is someone goes through a ceremony where they get an official piece of paper, and they also go through a ceremony where they take certain vows and make certain promises. And the Supreme Court of Canada takes that stuff very seriously. There's a big distinction between folks who marry and folks who don't. The Supreme Court of Canada has said that folks who marry, who take those steps and those vows, have understood and signed on effectively to a partnership where they understand that, number one, under the Family Law Act, all their assets that exist on the date of separation, minus those assets that they brought into the marriage on the date of marriage with certain exceptions, are going to be divided 50-50.
Yes.
Not so with common law.
Oh, really?
There is no presumption of 50-50, what we call equalization of property or net family property in common law.
But isn't it called common law marriage?
No, so that's a misnomer. It's like military intelligence, jumbo shrimp, friendly war, progressive conservative, I could go on and on. I probably will. No, it's not a common law marriage. In law, it's a common law union, if you will, a common law partnership. But a marriage is like being pregnant. You either are or you aren't. So a common law union or partnership are people who have decided that while they want to live together, share those various benefits, they don't necessarily want to commit to the contractual or the legal aspects of a marriage, which implies, firstly, that 50-50 sharing of assets in the event of breakdown of that marriage. So that's the first aspect. The second aspect is spousal support. If you marry and you're a spouse, there's an automatic entitlement to spousal support on separation, regardless of how long you've been together. Whereas common law, you have no right to claim spousal support.
Oh, really?
Unless you've been living together continuously. For how many years? For 3 years, or in a relationship of permanence as a result of which there is a child born. Not adopted, not brought in, not somebody else's, but a child conceived of that common law union. So those are the first basic differences. Now, that would be too simple, and lawyers wouldn't have jobs. So we had to make it more complicated. So what we did is, over the years, lawyers have challenged common law relationships by saying, well, it's not fair that these two folks have been together, let's say, for 25 years, not married. They did everything together. They worked hard. They pooled the resources. They pooled their efforts. One of them came out with all the assets. The other one came out with nothing. Like that old country and western song, I got the gold mine, she got the shaft. So they created the concept of a constructive trust, which in a nutshell says, and it's not necessarily restricted, by the way, to romantic unions, if two or more people work together and combine their efforts to acquire assets, and one of them acquires those assets and is enriched to the detriment of the other, who is correspondingly deprived, i.e., in English, we worked together on the farm for 25 years, but the farm was always in his name. When we split up, he kept the farm, which is now worth $3 million. I got kicked out with my suitcase and my toothbrush, and I got nothing.
That does not quite seem fair.
Supreme Court of Canada, in a case called Pectus and Becker, basically found a constructive trust in the interest of the lady who came out on the short end of that deal and found that she had an interest in that property. Now, the interest is not necessarily 50%. You need to calculate and determine the value of that interest, and you need to figure out how much that person who's not a titled owner contributed to the asset. So if you figure out that they put in money, that's easy. You can quantify the money. If, on the other hand, it's things like labor, let's say this person helped build the roof and did the renovations and plowed the fields and milked the cows, to use our farm analogy.
Right, they contributed to the property.
Then you quantify
Yeah.
the value of that, and you then award them a percentage or a dollar value interest in the property that's not necessarily going to equate 50%. Now, I can tell you that in a long-term relationship, where the parties effectively act as if they were husband and wife, just without jumping the broom, if I can use the analogy,
Yeah.
then the courts have now found something called a joint family venture,
Yeah.
where they basically say, well, even though you didn't get married, we think you were, you may as well have been married, you did everything else except go get the license, so we're going to treat you as if you were married, and we're going to divide it all 50-50. We're calling it now a joint family venture. Fairly new creation that's only been around for the last couple of years.
Okay.
But the big difference is, when you walk into court and you are married and you are separating,
Yeah.
you are automatically entitled to that 50-50 division of assets.
Right.
You're automatically entitled to spousal support, provided that you meet the entitlement requirements and provided that the incomes are such that they can afford to be paid. If you're living common law, the automatic entitlement does not exist. You have to establish the entitlement, and then it has to get quantified. So it's a more complex exercise.